Next
call
witness.
Ben Lohman, please. Hi, Mr. Lohman. Could you state your name for the record?
Benjamin Meadows Lohman.
And where are you employed?
I work for the West Virginia Department of Environmental Protection, Division of Mining and Reclamation.
And what's your job title?
Environmental Resources Analyst.
How long have you done that?
The current job for a little over 2 years.
And before the 2 years, where were you?
I worked with the Division of Water and Waste Management for a little over 10 years.
Could you describe what you currently do?
I work with endangered species. I'm, by my education and training, primarily an aquatic biologist, but I do deal with endangered species. I have a background in toxicity testings, particularly with selenium, and have done a number of issues, but primarily in the realm of aquatic biology and endangered species issues.
Okay, and were you here for the testimony of Mr. Doug Wood on last Monday?
I was not here in this room, but I was here in the building and did hear the testimony.
Okay, it's available online.
Correct.
And did you hear his testimony with regard to Kanawha Fork?
Yes.
And
Yes, I did.
The biological condition of Kanawha Fork.
That's correct.
And did you have an opinion about that testimony?
Objection. It requires a narrative. If he wants to ask him a specific question, he can. He can't just ask a broad narrative.
I was criticized earlier for asking leading questions. Now I'm trying to let him explain his thinking.
Can you rephrase it a little bit?
We all go to law school.
I have an instruction to opposing counsel to refrain from making personal comments.
Yeah, we have seen a little bit of disrespect to other attorneys and also to witnesses, and we'd appreciate if we could refrain from that.
Mr. Lohman, did you hear Mr. Wood's testimony with regard to potential stressors in Kanawha Fork?
Yes, I did.
And are you able to determine what, if any, biological stressors are present in Kanawha Fork?
Determination of stressors to a biological community requires more than just a single observation or a single walkthrough. It requires multiple lines of evidence be examined to determine what the causative agent is behind the being or the status of a biological community, particularly a benthic community, whether it is impaired or not. I did this for almost 10 years with the TMDL program, determining what the causative agent was behind impaired biological communities, so pollution budgets could be developed to restore those acceptable biological conditions in streams. And certainly not enough information was presented based upon the single biological sample without a review of an exhaustive review of the chemical history of exposure at that site and the consideration of the other factors that can cause biological impairment that were documented at that location.
And let's talk about those. What other factors are there?
Clear evidence of sedimentation to the degree that it limits biological potential.
And sedimentation, when Mr. Wood wrote his memo, could be caused by what activities?
I'm going to pose an objection because I don't think this gentleman's been qualified as an expert, and it sounds like we're going into an expert testimony realm. If he's
You
going to
want
provide
that?
opinion, I think it has to be.
I'm not offering him as an expert witness. I mean, he's an employee of the DEP and been asked to
He's
provide
asking to
truth.
express an opinion. That's only an expert witness can express an opinion.
Well, if he's not asking for a professional opinion and he's asking for his basis of knowledge and what he is used to exercising in the DEP, then I think the board would allow that. We're interested to hear the logic behind decisions that are made by the DEP. So we'll take into account the fact that he's not asking to be an expert, but we would like to understand how the DEP is applying situations. So go ahead, please.
Could you repeat the question? I'm sorry.
What could have been causing the sedimentation?
Sedimentation sources can be caused by multiple activities. Roads, typically, some sedimentation is natural in certain watersheds, but the key is that these macroinvertebrates, the benthic organisms that were the point of discussion and the resultant subject of the impaired or purportedly impaired biological condition, they require spaces in between rocks to live. And simply put, if sediment fills those spaces, they get displaced. So sedimentation can occur again from numerous activities, roads, land use activities, but there was certainly enough evidence of the effects of sedimentation at that location to indicate that it is a potential limiting factor to the biological community.
Now, Mr. Dugwood testified about sampling that he took in, I believe it was 2010. Could mining under the permitted issue here have caused that?
Objection, requires an opinion.
Okay, that's actually just a matter of fact. I mean, it's literally an either-or question,
No,
and
it's
this
not.
mine
It's an
didn't
opinion.
exist.
Ask him
I'm
for his
speaking,
judgment.
sir. Could you please let me finish my sentence?
Just let him finish.
The mine didn't exist in 2010, so it's an either-or, yes or no, black and white answer.
Yeah, we're gonna allow that question.
No, it did not cause or contribute to that condition.
Now, you also heard Mr. Dugwood testify about the existence or non-existence of mayflies. And you know what? Where did you go to college, sir?
Marshall University,
And
a
what-
master's degree.
What degree did you take as for your undergraduate work?
Excuse me, my undergraduate degree is in environmental biology.
And you mentioned that you have a graduate degree.
Yes, sir.
And what is that degree in?
In biological sciences with an emphasis in aquatics.
Okay, could you describe briefly what that entails?
Courses in ichthyology, the study of fishes, limnology, the study of freshwater ecosystems, as well as other wildlife courses, ornithology, herpetology, principles in conservation. All those courses were ones that I've taken.
Since your graduate work, have you taken any further professional courses with regard to aquatic biology?
I've taken training courses primarily in identification of aquatic organisms and you have freshwater mussels, for example. But in terms of ecology courses, actual full semester long courses, that concluded at the end of my college career.
Okay, I'd like to offer this witness as an expert in aquatic biology.
Anyone object to that?
Cal Farr, you're the witness on a couple of issues.
Sure.
Where do you work?
I work for West Virginia DEP Division of Mining and Rec.
And you're paid by the West Virginia DEP?
Yes.
And your intention is to provide expert testimony for the West Virginia DEP?
Yes.
I would object because I believe that the providing expert testimony for his employer is improper. I think he's too biased to be able to provide expert testimony.
Well, I think we're gonna go ahead and allow him to be qualified as an expert unless someone on the board has any questions. Or you have further questions you'd like to ask him?
No, thank you.
I think his experience demonstrates that he has those
I
qualifications.
did have one question. Who did you get training from at DEP? I'm sorry.
Jesus.
Who trained you with respect to your positions at DEP?
Multiple people.
Okay, one of them to my right?
I was trained on a collection technique that was used according to the protocol to collect these benthic organisms. One of the many people was Mr. Wood.
Thanks.
Any other questions? The board's gonna recognize him as a witness in these aquatic, as an expert, I'm sorry, in the aquatic biology.
Thank you. Now you also heard Mr. Dugwood's testimony with regard to the mayflies, I believe they were.
Yes.
Could you
yes.
describe for everyone what a mayfly is?
A mayfly is one of the members of this benthic community. It's an insect. It's a very short-lived adult insect. A life cycle as an adult. What I'm talking about is the flying fly part of its life cycle. It's usually very abbreviated. It lives in a larval form for some period of time prior to hatching out as an adult. What you're describing is a relatively large but primitive order of aquatic insects, order Ephemeroptera in particular. And there are numerous species across North America and across the world. And, you know, mayflies are indeed a common component of our streams, but also a very transient component because of this life cycle where they can hatch and no longer be part of the assemblage.
And you heard Mr. Dugwood testify about, I believe the word he used was extirpation.
Extirpation.
Could you define extirpation for everyone here?
Extirpation is an ecological term that denotes localized extinction. That means that the organism is no longer found in part of its historic known range. You know, extirpation is usually used, for example, in the realm of endangered species to denote areas where something was last seen but no longer seen.
Is a mayfly, or are the mayflies at issue in Mr. Wood's testimony, are they listed on the endangered species list?
No, sir, they're not.
Okay. You heard Mr. Dugwood's testimony with regard to the alleged extirpation of the mayflies. Did you take any issue with how he came to that conclusion?
I did. I think that, you know, ecologists are typically very cautious in the terms that they use, and extirpation is a very sweeping concept that would require multiple investigations and certainly a more thorough search of a local body to classify an entire order of insects as being extirpated. That's a fairly sweeping statement based upon one biological sample. And I'd like to add that in these biological samples aren't actually entirely examined. It's a time-saving technique to take a subset, it's called a subsample, of an entire collection and then extrapolate what the rest of the community is based upon a small census. So the entire sample that Mr. Wood collected wasn't even entirely examined to determine if mayflies were present in that very sample.
What would you do now to, if it were necessary, what would you do now to determine whether mayflies are indeed extirpated from that area?
You would have to do a more thorough examination, more thorough biological monitoring
What does that mean?
of the stream. You have to go out and do more collections to determine, in fact, whether the mayflies are there or not.
How many collections? 1, 2, 20?
Well, certainly more than one, but you know, to determine a sweeping extirpation claim, several.
Over what period of time?
A period of time primarily when you know that those flies aren't going to have hatched. So I would put a moratorium around late May and early June to not collect during that time period, because that's the time when most mayflies are adults and you won't find them in the assemblage. A more appropriate time would be earlier in the spring or even the winter to
Mayflies-
examine, to determine if mayflies are in fact present. Sorry.
Didn't mean to interrupt, sorry. Mayflies aren't a species that DEP needs to consider at all when deciding whether to issue a surface mine permit, correct?
That's my understanding, correct.
Just a moment, please. Do you have any experience in your education with bird species?
Yes, I certainly do.
Could you describe that experience?
I've been a bird watcher as a child. Like I said, I had a course in college to identify birds through primarily their sounds, their calls. I've done point counts for bird species for the West Virginia DNR before. It's a hobby. I mean, it's not a professional certification, and I certainly, have spent enough time doing that.
So you wouldn't hold yourself out as an expert in birds, would
I'm
you?
not an ornithologist.
Bearing that in mind, here in Kanawha County, have you ever seen a bobolink?
I have personally never seen a bobolink in Kanawha County.
Have you ever seen a dick sissel?
No.
Okay. How about a Henslow sparrow?
No.
A golden-winged warbler?
Yes.
A northern harrier?
Yes.
Now, what I've been looking at are the maps that I don't really know much about that Mr. Doug Wood relied upon during his testimony or referred to. Do you know what I'm talking about?
I do.
If I might approach, I'm going to hand these to you, and I, again, understand you're not an expert with regard to birds, but are these maps familiar to you?
Yes, they are. These are maps that are part of a endeavor called the West Virginia Breeding Bird Atlas that collates and documents locations where birds have been observed during their known breeding season.
What does that mean?
Okay, objection. He's already said he's not an expert. I mean, if he wants to call an expert, he can, and we can get a great discussion of all this. He's asking him to educate the board or discuss this at some length on a technical capacity. He's disclaimed any expertise in the area.
Let's let him tell us what his perception of that book is, but not, maybe not in great detail, but just his general perception of it. I think we've allowed that type of testimony on both sides.
And that's basically the question, sir. What does that book tell you? Or what's it designed to tell you?
It describes known occurrences of bird species when they are breeding. And that is that's a narrow window of time within a bird's overall life history. For example, a breeding season can be a 2-week window a year, or 2-month window. So it is not a comprehensive range map of all the habitats that birds use during times when they are not breeding. For example, winter habitats or foraging habitats.
I appreciate your time. I don't have any other questions for you.
Just starting where we finished here, and knowing the locations of birds' breeding grounds would be important ecologically, would it not?
Absolutely.
And particularly if you're trying to assess the impact of a particular activity on potential habitat for that species.
It potentially could.
Okay. And in reviewing the 5 different species of birds that you testified, correct me if I'm wrong, but there were 3 of the 5 you had never seen in Kanawha County. The other 2, if I understand it, but correct me, not during any breeding season.
Not during a breeding season. That would probably be accurate to say that the northern harrier observation would not have been during its breeding season. Although I can't recall. Northern harrier is a very common bird.
Okay.
In West Virginia.
If you're trying to assess the impact of any particular human activity on aquatic or terrestrial surfaces, endangered species list is not determinative, is it, of whether that particular activity is either good or bad, has a good or bad impact on biodiversity?
We really don't measure things in terms of good or bad. I mean,
Okay.
the regulations are what they are. Certain species warrant protection, and those are typically the species that are listed, and everything else is considered to be abundant enough that it can sustain at a population or species level those impacts, and that's just the way that that determinations of that sort are made.
Okay, and you said a number of times, I believe, that simply taking a single sample is not adequate for purposes of assessing the impact of the activity, whatever it is, on that particular species. Is that correct?
Well, what I said was a single sample would not be sufficient to provide the multiple lines of evidence that will be needed to determine something like biological impairment, for example.
Okay, in fact,
Or-
go ahead, you finished?
I was just going to add the single sample that I was talking to was the walkthrough with the conductivity meter that Mr. Wood referred to, and then the subsequent memo where he denoted that as being the sole source of the degraded biological condition.
And that was the June 3rd walkthrough, correct?
Some time around there, I believe it was.
Okay, but do you recall that in the memo that he sent, he also mentioned on June 8th, he had done a follow-up investigation?
I think that's what we're referring to, is the follow-up.
Okay, so there would be two observations then, if I understand it correctly, is that right?
Two observations of,
The biological phenomena present at the Canal Fork on those 2 days.
well, as far as I know, only one biological sample was taken. We're talking about water chemistry monitoring. Organisms is made.
And to come to the kind of conclusions that you mentioned with respect to extirpation, if I understand it, it's your testimony that you'd have to do multiple collections of data and an analysis over a fairly significant period of time.
I would be very hesitant to use the word extirpate as an ecologist.
So that's a yes, right?
I would want to see a more sweeping review of that to make that claim of extirpation.
Okay. To your knowledge, has DEP ever done that in this particular locale for those particular organisms?
Make an assessment of whether something's extirpated?
Yes.
To my knowledge, we don't have anything that's really endangered in terms of aquatic insects. So in terms of extirpation, you're going out to determine if something is wholesale eliminated from a watershed, for example. To my knowledge, those types of assessments are not routinely done.
Okay, but before you could come to the conclusion that there was nothing at risk, you'd have to do a study, wouldn't you?
You would want baseline information, but typically in terms of these insects, they have a flying portion of their life cycle, so they're not necessarily limited by immediate activities.
Okay. Did you understand Mr. Wood's comments in those two different memos to be that DEP ought to conduct the kind of analysis you talked about in order to create a baseline so that it could be available for assessment after mining activity began on that site?
My understanding from reading Mr. Wood's memo is that he recommended that Hoffman Hollow be used as a baseline indicator, if I read that memo correctly. And I since have reviewed the biological data from Hoffman Hollow, and on one sample event, 1 point on the Websky score of what his sample that he took in Canal Fork scored.
And that was in one instance?
That was in 2004.
Okay, and how many other instances were studied?
Hoffman Hollow is monitored thoroughly.
Mhm.
The point is that
What's that mean, thoroughly?
multiple times.
Over how many years?
Hoffman Hollow, because of its proximity, has probably been monitored biologically 10 times, let's say. I don't know a number specifically, but
Was Hoffman Hollow ever sampled in June?
not to my knowledge, not one that I saw. I do not recall that, so perhaps it was, but I don't specifically remember a June sample. The sample that I'm referring to that was within 1 point of the biological score that occurred in Canal Fork, I believe was an August 2004 monitoring sample.
You made the observation that in 2010, obviously, the mine proposed to commence here in 2014 was not in operation and couldn't have caused the kind of impact that Mr. Wood observed. correct?
I would not have drawn that conclusion.
It would be a pretty hard conclusion. Did you understand his testimony to be that the mine permitted in 2014 caused the 210 damage? Did you understand him to testify that way?
That the mine permitted in 2014
Right, yeah.
caused
I mean,
the 2010
Be a pretty
damage?
preposterous idea, right?
I
You didn't think that's what
I
he
didn't draw
was
that
saying.
inference, no.
Yeah, and you didn't think he did either, did you?
From the memo that I read, the inference that I drew is that Doug was indicating that he had determined what the source of that biological degradation was, and that degradation had occurred due to some mining activity.
Right. Are you familiar with KD site number 1?
No.
Are you familiar with the Rush Creek mine site?
I know generally where it's at.
Okay. Either one of those involve Canal Fork?
I have no specific knowledge of that.
Okay. Nothing further.
Questions?
Nothing, sir.
Mr.
No
Jones?
questions.
No questions? From anyone?
No,
How
sir.
about the board? Do you have any questions?
One question. I believe you were saying that Mr. Wood's sample, since it was only a single sample, was not enough to determine if the stream was impaired, et cetera.
Well, what I meant to say is that his assessment, the follow-up water chemistry assessment, would be insufficient to determine what the stressor of that biological community is. Now, it would be nice to have multiple biological samples to, in fact, confirm whether an impairment is existing at that particular location. But in terms of basing an entire causative source assignment to a stress biological condition, it requires much more rigorous evidence than a walkthrough with a conductivity meter saying that we've got high conductivity and a biological degradation, therefore conductivity is the cause of that biological degradation. That's not the way that the stress certification process worked when I was a part of the TMDL program. Multiple lines of evidence were considered, and it kind of goes back to, you have to consider the evidence that's on hand, and evidence that I saw clearly indicated that sedimentation impacts were occurring. There were oil and gas activity contributing oil during runoff events directly upstream of the location. All of those lines of evidence have to be considered and fully fleshed out before you can make a determination for what is the stressor to a biological community. Because based upon that, you're going to determine what pollutants need to be reduced to return that biological condition to an acceptable level. So it did not meet that level of rigor in my mind.
Does the department plan on doing that type of an assessment?
For impaired streams, for streams that are really impaired based upon that biological sample, it will have a TMDL developed, and that stressor identification process performed on that assemblage to determine what, if any, pollutants need to be reduced so that that biological community can return. And to my knowledge, Canal Fork is not considered an impaired stream.
But the
Well, it is impaired, but not for biological conditions, to my knowledge.
Would you plan to do a study to see if in fact that's true?
I personally do not plan
Okay.
to do a study.
On conductivity, currently the DEP uses a different standard than what EPA uses.
Uses a different, we don't have a water quality standard
Why not?
for conductance.
EPA does, correct?
EPA recommends a benchmark value
Uh-huh.
for conductance. Conductance is a plethora of free ions, some of which are beneficial to aquatic life, like calcium, some of which can be detrimental. Metals that are in solution, for example, in combination with pH, can add to ionic concentrations that are toxic to aquatic life. So conductivity as a whole is a broad measure of free ions in the water, and is in and of itself not, in my mind, a pollutant that can be reduced based upon its presence or absence to determine a stressor. The individual ion that is present and reflective of that conductivity must first be identified to determine whether it is in fact a harmful or perhaps even a beneficial ion to the water.
But EPA has a standard that they recommend that you use. Why don't you use it?
I personally am not in charge of determining, that would be a question for the water quality standards folks. personally would not use it because it is not definitive enough in that ionic signature to use in that realm. You know, you would have to identify again the ion of that conductivity that is present to determine whether it was at a harmful level, and not conductivity as a general term. Electrical conductance is measured through the free ions in the water can be, multiple things. Seawater, for example, has a high conductivity, but the component ions are quite essential and necessary for that type of marine life. So, you know, the conductivity in and of itself does not demarcate a toxic threshold.
Okay, so you're saying that it's better not to have any standard than to use an EPA standard that you don't think is?
I would say that it's more important to have the right standard rather than a standard that can also cover, for example, when the West Virginia DNR treats streams that are impaired for acidity, they increase the conductivity of that water with beneficial calcium hydroxide ions. Now, I don't think that anyone would argue that liming of acid streams is a detrimental thing, even though it increases conductivity. So it's very important to identify what that ionic signature is, rather than as a shotgun approach say that we have a conductivity of a certain level and therefore it must be reduced for the sake of the in-stream biology. I lean more toward the specific identification of problematic ions, like the other pollutants are.
Thank you.
Yes, sir.
Limestone treatments have very specific purposes, don't they?
Usually to ameliorate pH issues.
And
And I just interpose an objection. I mean, I think the line of questioning has been closed.
Well, yeah, if you have some specific question that you
well,
can just generate.
it's his testimony. that
Right, I understand. If you have a question about the testimony, ask the question.
Regardless of any determination of cause, do you agree that the bioassessment that was made in June 2010 indicate an impaired stream?
By the standards that exist today, a Websky score of 68, that stream would be considered biologically impaired.
Okay. And again, admitting the existence of more than one ion out there, nonetheless, conductivity is a stressor with respect to biologic life.
It can be.
Okay.
Well, I'll say ionic concentrations. I hesitate to use the word conductivity because that's just that's a measure. That's like saying that temperature can be a stressor. Well,
And it can be, right?
well, at a certain temperature,
Yeah.
not temperature as a whole.
The Canal Fork is listed as impaired, correct?
I believe it is listed as impaired for iron and fecal coliform bacteria,
But not biology.
not biological
And
impairment.
Do you know why not?
I do not know why.
Nothing further.
Mr. Walling, got
I have
anything
nothing,
else?
thank you.
Anyone else?
Just one quick question. Conductivity is generally measured at 25 degrees centigrade, is that correct?
Conductivity is typically calibrated at 25 C,
20.
but can be measured
Yeah, whatever.
at multiple.
But it's calibrated to 25.
That's right. That's typically the baseline that you use to.
And of course, we all know the oceans are full of a lot of aquatic life. What would be the conductivity of a typical sample of ocean water?
Seawater, several thousand. I honestly don't know specifically, but it would be in the thousands.
All right, thank you.
Thousands of microsiemens per centimeter.
Any other questions?
No, sir.
You're excused, thank you.
Could you bring the book, please,
Yeah.
since you're on your way? I'll call Mr. Kevin Siegel.
Before we go on, he said earlier, not him, but the other one, said there were no caves.
Who is it again?
Steven Siegel, the guy plays it.
Oh, the movie.
Edgy going, edgy going.
All set? Hi, Mr. Siegel. Could you introduce yourself to the board, please?
My name is Kevin Dwayne Siegel.
Okay. And where?
Absolutely. It's S-E-A-G-L-E.
And could you, where do you work?
I work for the Department of Environmental Protection.
What's your title?
I am a environmental resources analyst.
What do you do in that position?
I currently work for the Division of Mining and Reclamation. I process narrative water quality standard monitoring that is placed in coal mining permits within the MPDS program.
And, did you go to college?
I did.
Where did you go?
Virginia Tech. I have a bachelor's, a BS in biology.
Did you do any graduate work?
I have pursued an environmental science master's degree, but have not completed that one.
How many hours in are you?
About 16, I believe. Not very far.
And you testified that you're involved with the application of narrative water quality standards. Is that accurate?
That's correct.
How are narrative water quality standards protected when coal mines are permitted through DEP?
We apply the permitting guidance for
I'm
surface.
sorry, let me stop you real quick. Let's back up for a second. What are narrative water quality standards?
They are the regulations in 47 CSR I think it's 32E and 32I that state above and beyond the numeric standards, a set of descriptions that are not to be met to protect beyond what the numeric standards would necessarily catch.
And let's break that down just a little bit more, because we're talking to a lot of people who, on the internet who may not be familiar with what any of this means. What's a numeric water quality standard?
Yes, sir, absolutely. A numeric water quality standard would be a standard for something such as iron that has a number, a specific concentration that's not to be exceeded in the water column. Iron, aluminum, manganese, there's a bevy of parameters that have specific values that are not to be exceeded, and those are to indicate impairment if those are exceeded at a particular frequency.
Okay, and then could you explain what a narrative, then, in that context, what a narrative water quality standard is?
Again, it basically describes that the stream shall not have a particular set of descriptions. It would be better if I read the reg for you, but basically it describes that it shouldn't smell bad, it shouldn't be cloudy, things along those lines.
And how are those applied when you're trying to determine whether to issue a mining permit?
We have a document called, go ahead and just read it's the permitting guidance for surface coal mining operations to protect West Virginia's narrative water quality standards.
Okay, and what does that document do?
It looks at the properties of discharges based on the likelihood that those discharges will flow with through precipitation or through means other than precipitation. Say an in-stream outlet would be expected to flow at all times versus many on-bench outlets are expected to only flow in direct response to rainfall. And then based off of that determination, a set of monitoring suites or different types of control measures put in place to ensure that the narrative standards are not violated. And we just follow that policy by making those determinations on the outlets and then applying the prescribed monitoring.
Now, on the permitted issue in this case, the KD2 mine, are narrative water quality standards required?
Well, yes, narrative water quality standards are protected for all permits.
Okay. And how do they apply in this situation?
Originally, there was a valley fill that was in the mine plan. At that point, there were benthic biologic assessment stations that looked at benthic monitoring, chemical suite of monitoring and habitat, that valley fill, and wet testing at the outlets, whole effluent toxicity testing at the outlet. That valley fill was removed from the mine plan, and at that point, the rest of the outlets were deemed to be precipitation induced, or again, only flowing in direct response to precipitation, and those type of outlets do not apply, or we do not apply the monitoring to those type of outlets.
So biological sampling is not required for this permit,
No, it's not.
and those valley fills are no longer provided. Are valley fills provided for anywhere in the permit as issued?
No, they're not.
If there were still valley fills as part of the permit, what would we require?
We would require wet testing at the outlet and biological assessment stations downstream of the outlet and upstream and downstream of the next receiving stream.
And again, what would those indicate? What would those monitor for?
You are going to take a baseline biological sample in your biological assessment stations, and then monitor annually to look for a departure from the baseline condition to determine if there are any impacts from the discharges. Additionally, there would be whole effluent toxicity testing out at the outlet that would determine if the discharge itself was toxic or not, according to that protocol.
But according to the statutes and regulations that govern whether to issue a permit in this case, those are no longer required.
They are not.
No further questions.
Do you know Doug Wood?
I do.
Did you work with him at any point?
I did.
Were you ever trained by him?
I had many individuals that trained me. Doug was one of those individuals.
Nothing further.
No questions right now.
No questions, thank you.
No question.
Does the board have a question? I guess you're excused then.
Thank you. We have nothing further.
Well, I guess you have somebody
Our
like to
turn.
call? Your turn.
I'd like to call Linda Torrey.
Thank you.
Thank you, Nick. Thank you, Nick. Ms. Torrey, would you state your name for the record, please?
Yes, my name is Linda Torrey. The last name is spelled T-O-R-R-E.
Ms. Torrey, I have provided the board and council here present with a document that I would like marked as Permittees Exhibit 1, which is a document I would like you to identify, please.
It's like a resume that I've provided to you.
And it is a resume that you previously testified to before this board.
Yes.
I would like the board to recall, if it would, that Ms. Torrey was qualified previously as an expert, and I would like to move that that qualification continue for the purposes of this questioning.
Any objection to that?
Well,
Yes, sir.
I guess I object to the undefined scope of the expertise.
I will be more than happy to read it. She was previously qualified as an expert for the preparation, submission, implementation, and maintenance of surface mine permits in the state of West Virginia. She was qualified, or has a professional engineering registration in 2 states, including the state of West Virginia, and I think also pending in 2 additional states.
And I'm not trying to be difficult, I just can't
No.
write as quickly as
Okay.
Mr. Hoyer. Preparation, submission, and what else was it? Of surface mine
Preparation,
permits.
submission, implementation, and monitoring of surface mine permits. I think her testimony was that she had prepared some, I think either 57 or 77 permit applications.
And what is she going to be offered for today?
She is going to be offered as an expert to testify on some rebuttal to witnesses previously provided by the appellants in this case.
Okay, I guess maybe, and let me explain it this way. When I asked Mr. Woods to prepare a CV that was, as I believe Mr. Rouse last time commented, tailored to this board, I asked to do it in a functional way so that we could understand his skill set and why it was or was not germane. I'm not opposing this time, but I'd like maybe an opportunity to do a little bit of voir dire so we could just find out functionally what these words mean.
She's already been
yeah.
recognized as an expert,
Yeah.
but
Are you asking us to recognize her as an expert in the same area that we've already
precisely.
recognized her in this
Precisely.
case?
My sole purpose of simply getting her resume before this board is, we all know, this goes up. It does not go up de novo to circuit court, and I simply want to get her resume in as an exhibit in this matter.
I have no objection to the exhibit. Let me maybe clarify my question, and I'm not trying to be hyper technical about this, but the identified area of expertise, it talks about the preparation, submission, implementation, monitoring of permits. Now, do you intend to talk about the surface mining permits?
Yes.
But I guess what I'm getting at is the focus strictly on the permit itself, or what is it about the mining activity? That's what I'm trying to
Right,
determine.
you know what? We've
can
qualified
object
her as
to
an
it.
expert,
Yeah.
Your Honor, we've qualified her as an expert. He gets to cross-examine her with respect to her testimony.
Well,
You want us to,
well,
you want a preview of her testimony? I don't get it.
No, I think he's concerned that, that we may be heading toward questioning her in an area outside the field of permits that she's been qualified as an expert in. And I guess, do we think we'll be outside the area of permits?
Absolutely not.
Well, then let's let him continue with this questioning. We can always object if she's outside her field of
That's
expertise.
fine.
But we've recognized her as an expert in the permitting section. If that's what his questions are gonna inure to, then let's do that.
Ms. Torrey, were you present at the last hearing? I can't recall the date.
August.
I think it was, one second. 8/11, August 11th of this year, when Mr. Thomas testified before this board.
Yes, sir, I was.
And were you present when Mr. Thomas expressed a concern regarding the potential impact that this surface mine would have on his well?
Yes.
And have you had an opportunity, Ms. Torrey, to review that testimony and to form an opinion as to whether or not the permit, as you designed it and submitted it to DEP, which was ultimately approved and is the subject of this hearing, will have any adverse impact on Mr. Thomas as
Okay.
well?
Excuse me, just an object, this is, maybe we can resolve it now. This is way beyond the question of monitoring of permits. The question is, what he's really asking her is, will this mining activity have an impact on this gentleman's well? Has to express an opinion about that. And you'd be the world's greatest expert on permits, and that doesn't tell you what's gonna happen as a result of the mining activity. And if he wants to qualify him on that basis, that's fine. But I mean, you know, this is exactly what I anticipated, and it's what I object to. She's not been, you know, they've only offered her as an expert on permits. What she's been asked to opine on is the impact of mining activity on a well.
I could go through it again if the chairman would so like, but she is a registered professional engineer. She did actually prepare and submit this permit for approval by the Department of Environmental Protection. As an integral part of that permit, she conducted or had caused to be conducted studies on the well water that is the subject of this question specifically here today.
I understand, the board understands concerns of both, and they're kind of integral here because the permit is designed to protect water. She has to do that in her discussion. Then there's a question of whether she would have the geological background and all to make a determination on what actually happens when you mine. And what I think if we're going to stay with the expert status we've given her, then I think her testimony would have to be limited, or her opinions would have to be limited to how the permit was designed to protect off water damage, and what she did as a PE in preparation of the permit. And if we're going to discuss, you know, the actual chances that permit will work, or that will function, or what might happen when we mine, then we may need another expert or a qualifier in another field. So if the questions could be directed to how she designed the permit, what she did in order to try to protect water, I think that's appropriate with what we've approved.
Yes, sir.
Go for it.
Ms. Torrey, can you tell the board how far the Thomas well is located from the active mining permit that you designed?
Yes, from the point of the permit that's the nearest to Mr. Thomas's house, to his house, just a straight line.
Can you talk louder?
I'm sorry. From the nearest point on the permit to Mr. Thomas's house, which is near the mouth of Canal Fork, a straight line distance drawn through AutoCAD to his house is about 2,300 feet.
Thank you.
And Ms. Torrey, the type of mining that is designed in this permit and that has been approved is a surface mine that requires blasting, is that correct?
That's correct.
And could you describe briefly to the board the type of blasting plan that is implemented on this permit?
Yes.
Okay, if I might, I just want to remove my objection. You know, she was described as an expert on permits. We've gone to hydrology, now we're moving to blasting. I'll note this now because I intend to cross-examine her on her qualifications for all these topics.
Understand, let's let her go forward. What we're trying to understand is what she did in the permit. She's the one that prepared the permit. We'd like to know what her points of reference were, what she did when she did the permit, and then you'll have a chance to talk to her.
Again,
Repeat
how
for me, please.
how was the blasting plan for this permit designed by you?
The blasting plan follows the protocols in the CSR 199, which is the Office of Explosives and Blasting. And specific to this permit, it has to address a multiple seam surface mining permit that does not have a preparation plant to wash the coal. So as blasting proceeds through the permit on the various strata, the care has to be taken by the operator that they do not blast the overburden down into the coal seam so that the coal can be taken out and placed into over-the-highway trucks right there in pit and then hauled off-site to their loading destinations. So that is a very controlled type blasting, and as I said, it does follow the requirements of the Office of Explosives and Blasting Regulation as well as the Mining and Reclamation.
And utilizing that blasting plan and following the guidelines that you referred to, is there any impact on the substrata below the coal as that blasting occurs?
Same objection.
Noted. Go ahead.
If the blasting is submitted, if the blasting is controlled enough so that it does not push the overlying rock into the coal, then I would not expect it to have an impact on the substrata below the coal, as the coal is typically a softer material than the sandstone strata that overlie it. Therefore, I think the blasting plans are designed to protect that product that the mining operator will haul off-site, therefore not affect anything below them.
And assuming that the blasting plan is adhered to as designed in your permit, and it does not impact the substrata below the coal, is it fair to say, in your opinion, that that would protect any potential damage to Mr. Thomas as well, who you testified is located some 2,300 feet from the nearest point of this operation?
And can I, just for clarification, to make sure it's not confusing, are we talking about damage from blasting? Is that what the question is, or?
It's damage in
Okay.
any nature.
Well, damage from blasting versus contamination, I think is different, so I just want to
She can,
clarify.
whatever she interprets damage to mean.
I would not expect damage from blasting. If I could further state, I wouldn't expect damage from contamination either, because I would.
I'm gonna object, she's not a hydrologist.
Yeah, I mean, I would kind of agree with that objection, and the board may have a question as to whether this is sort of how you design and in your experience, how you've prevented damage from other places, but since we have her qualified as an expert on the permitting part, I think that's what kind of relate that to maybe.
In the process of permitting this KD2 permit, was there consideration given to Mr. Thomas as well?
Yes.
And could you explain to the board what consideration in the permit was given to Mr. Thomas as well?
Our field staff contacted Mr. Thomas and some of the other residents down there and asked for permission to sample the well. If there were a site that we could obtain a sample without it being gone through a filter or some other treatment facility in his well. And he granted that permission. So included in the permit are a series of baseline samples, results, and one set of heavy metals, which is a requirement of the Section 4B of the permit. And a copy of that was provided to Mr. Thomas. This was about 2010. The sampling's been ongoing in that area for several years.
So in 2010, as part of the permitting process, you sampled Mr. Thomas as well, is that correct?
Yes.
And was that, what were the results of that well water sample?
They're included in the permit application.
Yes, ma'am.
But it was a neutral pH in the mid-7 range, low metals, a little bit of iron, but it went through the whole gamut of the 4B metals, the heavy metals that are required. So it had a sample result provided for, arsenic, cadmium, beryllium, chromium, silver, zinc, nickel, thallium, mercury, lead, and I believe the results on all those were either non-detect or extremely low levels.
And was there any follow-up sampling done to Mr. Thomas as well? And if not, why not?
Well, there were two samples that were collected in late 2013, and those were restricted to just what we consider the baseline parameters, which was pH, acidity, alkalinity, iron, manganese, total suspended solids, total dissolved solids, sulfates, I think aluminum and probably dissolved aluminum and selenium. And those all were within what the DEP would consider an acceptable standard for those items that were monitored.
Thank you. Ms. Torrey, were you also present when Ms. Bullis testified before the board here?
Yes, sir.
And she expressed concerns regarding the blasting activity that is necessary in order to conduct this surface mine permit operation on KD2. Did you hear that testimony?
Yes.
Could you explain to the board in preparing a surface mine permit for approval by both the DEP and the DNR, what considerations were taken into account as relates to the blasting requirements for that permit?
Within the mining and reclamation regulations, as well as the CSR 199, which covers the Office of Explosives and Blasting controlled activities, there are guidelines for the forms that we use to notify. There are specifications in there how the public notice should be presented. Those are all reviewed by qualified folks in the DEP, and we follow their guidelines. Typically, the public notices and the language in the notification letters that we send out to the nearby residents through certified mailing include a statement that no blasting will occur between sunrise and sunset. And that range of times is given, but typically mining operations will do their blasting near shift change between day shift and afternoon shift. That's a typical occurrence, and what is expected. It gives a less impact to the production, and it also allows a little bit on a safety margin for those folks, that they keep their operators away from the site of the blast until that blast is cleared. However, there are occasions, such as if there's a lightning storm that comes by and the mine has loaded holes, they may have to speed up their schedule. There may be times when they have to delay. There may be, because this is a pretty complex geology and we have multiple layered coal seams with shale and partings between them, that those partings sometimes have to be shot. So that puts them off schedule, and they cannot present the mining schedule to maintain a production in a real rigid manner. So they can't say for sure that it's going to be at 3:15 every day. They can give a range of times.
And you also heard, I think, her testimony as it relates to the various signage that is posted pertaining to the operation of the KD2 mine.
Yes.
And I think part of the testimony is that there were signs posted within the boundaries of Kanawha State Forest. Is that correct?
That's my understanding, yes.
And why would there be notices placed within Kanawha State Forest?
Well, it's not typical that that the coal company would do that. I don't know that it's required in the regulations, but I think in this case it was an accommodation and a precautionary measure. Most of the time, the signs are posted at points where there's a potential public access onto the mine site. And operators are very concerned, especially in our terrain, that we have a lot of back roads that can access into the mine site. So the main gate coming into the mine, which is typically controlled with security, and other roads that might have access into some point of the active permit, the permit boundary, there would be signs posted warning people that there is the potential for blasting to occur. Not typically do they go beyond the outline or the permitted boundary to post signs of that nature.
And what was the reason for doing it in this particular case?
I think it was more of a precautionary measure and just an understanding that there are folks that travel that Middle Lick Road.
And who requested that?
I believe it was requested through the reviewers of the blasting plan and the Office of Explosives and Blasting. It may have been after their consultation with DNR, but I'm not certain about that.
Ms. Torrey, one other thing I think that may be helpful to the board is the mine plan that is an integral part of the permit that you submitted and was approved by both agencies is essentially a mine plan that takes place over how many years?
This one is approximately 10, and then followed up with a period of reclamation.
Yes, and is it correct to state that there are approximately 7.2 million tons of recoverable coal on this permit?
Approximately.
And is it also fair to say that that 7.2 million tons is approximately what the John Amos plant would burn in a year?
Yeah, I'm gonna object on relevance, and again, just raise the objection on expertise. There's no foundation laid for expertise in permitting to allow you to assess tonnage.
Well, I think the permitting, the board would recognize, would allow a question as to the tonnage and the permits. That is an integral part of the permitting process. Whether she would be aware of John Amos's tonnage or use, I don't know. I mean, if the 7 million ton number is what you're trying to get to, and have us understand that,
Yes.
whether, I'm not sure she's
Yes, sir.
qualified to answer John
I'll
Amos's
withdraw that
usages.
question. Ms. Torrey, the accommodation for the signage then at the Kanawha State Forest, was it a negotiation that was conducted when the 10 cent a ton accommodation was done, or was that separate?
I think it was totally
Objection,
separate.
foundation. No
You
basis
don't
for her
know.
knowing when that occurred.
That's the last question I had, thank you.
Okay. Have any questions?
All right, if I might. Ms. Torrey, I've expressed obvious questions about the area of your expertise, and I'd like to go through your resume enough to try to clarify that. When did you get your PE certification for the first time?
In 1989.
1989.
At this point, I would actually like, just for the record, interpose an objection that I'm not sure that this line of questioning is necessary. I mean, she's not offered, but we're here to determine the.
Right. I understand your objection. And I guess the question we would ask is since she's already been qualified as an expert in permitting and she's testified along those lines, I mean, I don't understand exactly where we're going to, if we're trying to disqualify her now or if
No,
we're
no, let me.
arguing that she's outside of her testimony.
I wanted to find out what, if any, the skill sets that made her, qualified her to get her PE, what, if any, of those skill sets are relevant to the topics that she's asked to express opinions on?
Well, I think the board's already qualified her as an expert.
I understand that, but the board's also disqualified people from expressing opinions on the impacts of human activity on aquatic and terrestrial habitats because they didn't possess a professional engineer. And so I'd like to know what this witness thinks the importance of that is.
Well, given the fact that we've already accepted her as an expert witness in the area of permitting, unless you're arguing that she is somehow testified outside of her area, I mean, if you have a
Okay.
couple of questions that are important and can make them brief, I don't think the board minds if you'd ask them if you can make them brief.
Let me make this.
We don't want to get it on a tangent, you know.
I understand. I don't want to go on a tangent. But the last component of the permitting process that she was asked to talk about was the mine plan, which, and drawing up a mine plan is a lot broader than knowing how to fill in the blanks on a permit application.
Objection, Your Honor, or objection.
To me, please.
Maybe,
So I want to explore what's involved in what skill sets are involved in drawing up what a mine plan consists of, what skill sets are relevant to drawing that up. And
Don't know
then,
the
If-
permit, how can you do the permit?
I'm not sure council is headed in the right direction. When I got my PE degree, I certainly understood it to be quite broad in nature, and it certainly required me to have expertise far beyond filling out forms. So that question I would object to as to the form, if nothing else.
there are any number of engineering degrees in permitting. I mean, structural engineers, mechanical engineers, electrical engineers.
This is-
And what I'm trying to get at is what this person knows about mining.
Well, right. The board, I think, has to recognize that her her development of the permit probably entailed some input from other engineers and company personnel or whoever the permittee was, and that she had to dovetail that information into the permit. So she's got to have knowledge of mining in order to do that, and yet all the knowledge that she applied to this permit probably wasn't developed by herself. I mean, she probably had help. So if you have a couple of quick questions, I think the board could allow them if you're trying to define how much she relied on someone else or how much she relied on herself. But try to make them brief, please. I think she prepared this permit, so she obviously has some knowledge of mining.
All right, well, tell us what a mine plan is then, as a beginning point.
Mining plan begins with the geologic analysis that does an evaluation of the overburden, both the types of rock that are in it and the amount of coal in it. There's an exploration permit that is done ahead of time, isolated spots that are distributed across the mining site itself that include a 2-inch core hole. The core is analyzed by a person who is qualified, such as Reich Laboratories or other labs throughout the state that do an analysis of geochemistry of those cores. And typically it is the acid-base account analysis, and in recent years, elemental selenium analysis. Once the evaluation of that property is done, the seams that are considered to be mineable will be evaluated. There'll be, in some cases, if the mine is set up in such a way that the coal has to be washed through a preparation plant, there'll be washability studies done on the coal. But then the planning itself will include a discussion or an evaluation of the quantity of existing topsoil, places that are appropriate and accessible for that topsoil to be stored. It'll include blasting, fragmentation on a strata by strata basis. It'll include location of haul roads, drainage ways, a distribution of water across the permit and how it be captured in ditches. And then subsequently, it will be sequenced in as an excavation of overburden, a placement of that material, and the grading it into a stable configuration that is acceptable and is within the guidelines of the DEP technical manual and the regulations. So it has various components that involve geotechnical, geochemical, and stability evaluation of those burdens, both on a pre-mining and a post-mining reclaim basis. It includes an evaluation of the appropriate plantings to be put back on the reclaimed ground once whatever available topsoil or rooting medium is placed back on top. Those plans are signed off on by a certified professional forester if it is a forestry planning plan, which this one is now.
Okay, I want to ask, if, as part of putting together a mine plan, does your firm, in effect, take topological maps or other maps and design
Yes.
this particular permit has a highly phased.
Yes, it does.
You in effect, design or.
We evaluate the quantity of material to be excavated during each phase, and that is based on a 3D model using AutoCAD and some civil and mining software that interface within AutoCAD. So ServCAD is primarily the one that we used on this one.
Right, and among the things you undertake in the course of designing the sequence of the mining, correct me if I'm wrong, do you design the water catchment systems or the water?
We do.
The systems that move the water from one point to another?
Yes, we do.
Okay. And did you design all of the rain catchment systems or water catchment systems that are present on this permit, in this site?
Yes, we followed the guidelines that have been provided by the DEP through the technical handbook, as we have done for years. And it's the 0.125 acre-feet per acre sediment capacity, and then the surface water runoff analysis, which we had talked about in the previous hearings, that have the outlets of those ditches are designed based upon the sub-drainages that are conveyed through them.
Okay, apart from design, do you have a role, or does your firm have a role in monitoring or observing the construction of the
I have not done on this particular permit, but I have done on others.
Okay, do you know who monitored or observed the construction of the sediment ditches in this particular case?
I don't.
Did you have any role in the design of the sediment ditches, I should say, design and construction of the sediment ditches at KD1 or Rush Creek
Yes.
sites?
Yes.
And what was your role there?
We did the design on those permits as well, and I did the periodic inspection of the constructed ditches and certification of them once they were built to this size capacity. And then on a few occasions, after monitoring indicated that they needed to be reconstructed, then I would go back and recertify them once that construction was redone.
Okay, were you involved in the, you're aware that there were problems with SD 14 and 15 in this particular site that resulted in a cessation order?
I understood
Correct.
that, yes.
Did you have a role in the redesign or the reconstruction and certification
I
of
don't-
those ditches?
I had some discussion with provided some copies of the specifications out of the permit to another consultant. However, it's my understanding that they were not redesigned, they were just rebuilt.
Okay, and who was that other consultant?
I believe it was Accurate Surveying.
Accurate Survey?
Yes, sir.
Did your firm, you or your firm conduct the SWRA analysis, the surface water runoff analysis that
Yes,
was
sir.
incorporated into the permit?
Yes, we did.
Okay. You understand that analysis, at least the initial analysis, employed an incorrect soil survey, is that correct?
It employed a previously utilized soil survey that had been utilized from 2006 up until this year. So I wouldn't characterize it as incorrect. I would just characterize it that there has been one subsequently provided by NRCS that is a little more up to date.
And that 2013 soil survey is the one you're referring to, correct?
Yes, I am.
And is it accurate to state that it recharacterized from grade C to grade A approximately 58% of the land mass that's the subject of KD2?
It did, as well on a pre-mining basis, but also on a post-mining basis.
Okay. And did you participate in the, well, to your knowledge, was a new SWRA analysis prepared?
It was.
And when was it submitted to DEP?
It was.
When, do you know?
In July, I think around the 6th.
And what role, if any, did you play in that?
I supervised that, discussed the selection of the soil characterizations, and the PE who works with me, a gentleman by the name of Anthony Gatens, actually performed the said CAD runs. I reviewed the narratives in all of that and also the selection of the soil
Okay.
classifications.
Do you agree that it was an error to use the 2006 soil survey?
No, sir, I do not, because it had been utilized on permits that we've been conducting for preparing and designing for years, and I have no knowledge of any failure that has resulted from the utilization of the 2006 soil classifications.
Okay, well, certainly it would have been used in 2006 and 2007, 8, 9, 10, 11, and 12. I mean, it couldn't have been replaced by the 2013 survey in those years, right?
That's right.
But wouldn't the better engineering practice be to use the current survey?
Our analysis was done and had gone through technical review and was accepted. When those were published, we thought we were ready to be approved, and when we were asked to prepare that based upon the new soil classifications, we did so with the same result.
When you say the same result, what do you mean?
We had no changes to the design of the ditches, no changes to the design of the spillways, and we still met the criteria of no net increase of surface water runoff on a during mining, worst case, or a post-mining reclaimed basis.
What was the curve number under the later analysis?
It was less than the one on the first go-round.
Ken, what was that number?
I have to look at the sheet. There's a lot of numbers in that page.
Okay. To your knowledge, was any part of this revision of the SWRA analysis open to public comment?
It was a minor revision.
Objection, it seems that it needs to be.
It what?
I object. I mean, he's asking here for a legal conclusion as to whether
Well,
or
I
not
asked
it
her-
needs to be submitted. Let me finish, please, to public comment.
I believe my question started out was to her knowledge.
Answer the question, that's it.
Okay. We submitted this as a minor modification to the Oak Hill DEP office for review, and it was accepted and approved.
Okay, well, it was a minor modification in the middle of a litigation challenging
Objection.
it, correct?
Well, She's
yeah,
answered
no,
this.
yeah,
Okay,
ask her
how-
factual questions, you know.
How did, who characterized it as minor?
I did, I and my staff,
Okay, on the basis of what?
on the basis of, we were basically reiterating a process that we had already gone through and demonstrated compliance with the regulations. And it was simply a matter of changing, updating the soil classifications as they applied within the mining conditions that were already defined.
Okay, and you understand that by, at least so long as DEP accepts your characterization as a minor modification, it avoids in its entirety any public participation. You understand that?
I believe once it,
Object to his characterization. I mean,
She can
Well,
answer, either she understands that or she doesn't.
Go ahead and answer.
okay. I understand that a minor modification does not require a publication in the local newspaper, but it is my understanding that documents that go to the DEP, once they are accepted by the DEP, are available through FOIA. So they are publicly accessible documents.
You have done you responded, withdraw that. Are you familiar with the standards for professional qualification that the Department of Interior has adopted for persons attempting to assess the impact of mining or other activities on historic sites?
objection relevance.
Yeah, are we
Beyond
trying
our
to?
scope.
We're off.
Yeah, she's not testifying to that, is she?
Okay. You've submitted materials to the DEP relating to the impacts on historic sites, haven't you?
We have submitted materials to the DEP as required by the section of the permit, Phase 1 archaeological surveys and other assessments, yes.
Okay. And you filled out the Form MR-SHPO, correct?
That's correct.
Yeah,
It's
objection.
beyond the scope of the.
Well, are you trying to, I mean, what's the, are we trying to
I'm
get
trying to
here?
get the scope of her undertaking for the client. My impression is that she's prepared a great deal of, if not all, of the permit
She
application.
did. That's what she was
Right.
put on the stand
That's
to
right.
testify.
And these are components of that permit application.
That speak for themselves.
Well, yes.
Well, that doesn't mean that they're correct, and I'm entitled to cross-examination the person that
Right.
presented.
If you're trying to get to something of that how she did it or what she relied on, if you could go ahead and go to that and we
Okay.
can determine.
Who inside your organization prepared the submissions relating to historic sites?
Most of those documents I accumulated and forwarded in through the permit. So I think the cover letters mostly come under my hand if you looked at those.
Okay, are you familiar with, well, I'll skip that. Do you or anybody in your firm have a graduate degree in architectural history?
Again, I'm gonna introduce an objection. I mean, aside from being simply irrelevant, there's no requirement that anyone in this consulting firm have the qualifications he's citing to randomly, it seems like.
Well, it's not random.
If your
it's
question is how did she make archaeological decisions, is that kind of what you're-
Architectural, historic
architectural
architectural.
decisions? Or whether, or what she relied on, or whatever decision she made.
Okay,
for it.
let me make it real clear.
You could ask.
I wanna make it real clear. The DEP and Keystone defend the issuance of the permit on the basis of, without SHPO concurrence, on the basis of,
Objection.
Objection.
you object to my explaining?
Your
Yes.
the basis for-
characterization.
Yeah, you're characterizing what they're doing, right?
Well,
What's your, what are you trying to
I
get
mean,
to?
I'm trying to give the broad response to the question of relevance.
I want to understand the basis of his questions regarding these qualifications that he hasn't identified and for which we don't know where they come from, who they're required by, or anything.
Well, we can do this, we can have an elaborate discussion of the general requirements for the assessment of SHPO, or we can ask a few factual questions and debate the rest of this later.
Well, if you have questions about how she made decisions on architectural issues, then,
Well, no, they go to her competence to make those decisions, her recommendations.
well, I'm not sure we've established that she even made them.
She's not offered.
Well,
for
she,
that. She's offered as an expert
on the permits,
on
which
the
included,
permit that
which
she-
included the MR SHPO form, correct?
That's correct.
Okay.
Well, again, I think there's still an
Behind it,
objection
that won't
pending
fall.
here.
We
Where are
know
the
what he's talking
qualifications
about.
for first? I mean, I don't understand the basis for the question.
Well, they're the Department of Interior's
Maybe it will
standards for
fall.
professional qualifications.
And
Well,
by who are they-
let me go ahead. First, maybe we need to establish if she actually made all the decisions that are
And that's why I
architectural,
asked
not what
I
her
agree with that.
qualifications are.
I agree with that, and that's why I asked whether she or any person in her firm had these qualifications.
Well, yes, in order to satisfy all the parties here, maybe the best question, I'm not suggesting that you have to ask for this, but we need maybe to find out if she actually, her or her firm actually made decisions on architectural issues or not, and or whether she used maybe a consultant or something, and then we could, maybe the issue of how qualified she is to make decisions like that becomes more relevant.
Did you or any person inside your firm provide information pertaining to historic places or sites to the DEP as part of the permit process?
We compiled information that was prepared by a qualified architectural resources firm and an archaeological firm who conducted on-site Phase 1 archaeological studies and who did additional research into cultural and historical structures. Those folks are the ones who provided us the information which we included in the permit and forwarded to the DEP through the permit itself.
Do you know what the qualifications are of the firm that you consulted with?
I believe their credentials are included as an addendum to their reports, so those are included in the certified record.
Okay. To your knowledge, do those credentials include one or more of the persons in that consulting firm having a graduate degree in architectural history?
Again, I
Objection.
object.
Unless he
These-
gives her a copy of it, that's an unfair.
And
you
also,
want
he
that?
hasn't established that these are requirements, period.
It's a matter of law. These are published regulations.
No, but there is no regulation that says that those, wherever they come from, and you still haven't given us a full site, have to be held by anyone providing information to a permit writer or a permittee
Right.
to the DEP.
Well, like I say, we can.
We wonder what the relevance.
Well,
you
the
know,
the implementing regulations require all determinations with respect to historic sites be made by a competent person. Look, let me make this a little bit clearer. The first, the document which I introduced for the sole purpose of authentication earlier today, if you could turn to that, it's on page 100 of volume 2. And this is a memorandum of agreement.
And again, same objection with regard to that.
Okay, well, let me get my statements out. Do you mind if you just let me finish a sentence? If I could object is on the record, I'm sure you'll
Yeah,
object at the end
let's
of this.
hear
Let's
your
get full
logic.
sentences out there if we can.
Let's hear your logic.
Okay, page 100, this is a memorandum of agreement between the DEP and the Division of Culture and History and a particular applicant, and a memorandum of agreement. And on page 100, under stipulations, item Roman 2, it says, all historic preservation work carried out pursuant to this memorandum of agreement will be performed by or under the direct supervision of a person or persons, meaning at a minimum, the Secretary of Interior's professional qualification standards at 48 Fed Reg 44738-9. The DMR, Division of Mining and Reclamation, will consult with SHPO to determine and ensure that the preservation professionals responsible for carrying out the historic documentation covered by this MOA meet the Secretary of Interior standards. Now, I'll represent to you that that's not there by accident. That's there because that's the requirement of law. And so- and-
Where is that requirement? All I'm asking for is a regulation or statute promulgated by the legislature or by an agency of the state that contains that requirement, rather than it just being in some other memorandum
Yeah.
of group that I haven't even seen until this morning.
All right,
In addition, Keystone has the following objection. This has to do with another permit, with other people, under the rule of evidence 408. It's inadmissible. Doesn't have anything to do with anything. I don't know why we're referring to an agreement over another site we don't know anything about
Because
as to what the legal requirements are. In this case, it doesn't have anything, it's irrelevant and it's inadmissible under 408.
well, items 4 and 5, beginning at pages 21 and 45, are the regulations at 36 CFR Part 61 and Part 800, state procedures and the federal implementing regs for Section 106 of the Historic Preservation Act. Both of those regulations, in one degree or another, but clearly require that the person's making the types of determinations that are referred to in the memorandum of agreement meet the qualifications of the standard of the professional qualification standards for historic preservation issued by the Department of Interior. And this is not out of the blue, shot in the dark. I mean, these are regulations that have been in place literally for decades, since the mid-80s. And, this is not, we're not reinventing the wheel here. It's such a garden variety procedure that yes, it's incorporated boilerplate into all memoranda of agreement. So that's why it appears in that particular one, which is merely illustrative of the practice, not defining it in its totality.
If I may. My witness has testified that as part of the permit that she submitted, that she sought and obtained professional input for that permit, that those qualifications are a matter of record in this case. If Mr. DiPaolo sees an inconsistency because of what he's talking about, and I don't know what he's talking about, with the record, and if he could point that out, that's an appropriate question. But to have my witness try to respond to the permit that she submitted in comparison to a document she's never read is an unfair question. And it's not relevant to the issue before this board.
Well, I think the purpose, we started out that she was offered as an expert on permits. And I suspected, and I verbalized my concern at that time, that we're gonna get way beyond permits, and we have. We've gone hydrology and blasting, and now we're in the era of historic preservation. My pending question to her was, does she know what when I asked about her own firm and their role in it, she said basically they engaged a consultant. My question to her is, does she know what the qualifications of those consultants were by reference to the Department of Interior's minimum standards for qualifications in the area? And if I understood her question or response, at least initially, it was, well, it's in the record. And if that's all that there is in the way of testimony about that, that's enough. But I took the great risk of asking her if she knew if they had the very first qualification, and what I got was an objection.
Well, I don't think I'm not sure Exhibit 9 was ever admitted into evidence, and I don't think it was. And I don't think I understand the fact that there's not been a lot of basis laid for this. However, I also understand that there's some relevance to the fact, I think the board recognizes that you're wondering about things she did in the permit related to SHPO. And I think if maybe the particular question you have, whether the board's determining that they're even required to be, that this memo is even valid in this or not, we're not making a decision on that, but if she can answer or can't answer or doesn't know the qualifications of these people, then maybe we can make one question and have that done.
Are you familiar with the qualifications of the consulting firm that was engaged?
The consulting firm that presented themselves as experts in archaeological and architectural work and practice throughout West Virginia, then I accepted their presentation as it was approved by the company that we're doing the work for.
I understand that, and I take it, when you say with their presentation, you didn't do any independent examination of the professional degrees or background experience of the individual members of the firm.
I did not question those individual members of the firm as to their,
I understand. In looking at your resume here, I gather for the last roughly 7 years, since '97, you've been at Dakota Consulting. Is that correct?
since 1997?
97?
Yes.
And it says co-owner, are you, who are the other owners of the company?
Objection is irrelevant.
Is there relevance to this?
Sure, I'm trying to find out, who the entity is.
I think we're gonna deny that, and
Okay. And in the years 84 up to 97, you had engineering positions with Old Ben, Arch Minerals, and is it Catenary?
Catenary.
Catenary. What kinds of things did you undertake for those firms?
With Old Ben Coal Company in southern Indiana, I did planning and production. It was open pit surface mine in southern Indiana, and I did some work with mapping, some work with overburden calculations and pit layouts, budget preparation, volumetrics, and also did some monitoring of coal quality as it came through their prep plant. Southern Illinois, or southern Indiana coal, in the Illinois basin, it was all washed coal. With Arch, I came to work with Arch in southern West Virginia in Logan County. Again, my primary position to begin with was production and long-term planning, which looked at evaluation of potentially mineable tracts to determine the extent of the mineability, again, budgeting, long-term planning, reserve analysis, and worked with some of the on-site environmental technicians to do field inspections of ponds and ditches. Then with Catenary, I worked had several positions there relating to environmental compliance. Worked with our permitting staff in the central office. Also continued to do work with budgeting and long-term planning of some of the peripheral projects that Arch controlled at that time in southwestern Virginia, eastern Kentucky, and here in Kanawha County, and property that extended into Boone and Raleigh County. So,
Did you advise Keystone to commence the clear cutting either on May 5th or shortly thereafter?
Objection.
I
As to beyond the scope of the direct examination, and as to relevance. If there's a permit violation or something that's occurred, it's up to the compliance division of DEP to handle that. That doesn't have anything to do.
I'll withdraw the question. Did you I believe you testified that you've submitted or participated in the submission of a significant number of permits to DEP for surface mining, correct?
That's correct.
And have you ever had a permit for which a MRSHPO form was prepared, which was nonetheless issued, notwithstanding an objection by SHPO?
Objection relevance?
She's an expert in permitting.
It has nothing to do with the validity of the permitted issue in this case.
It certainly does. If she's done 10,000 and this is the first one that's ever happened, I think it's very germane.
The issue of whether
Well-
SHPO approved.
Yeah, I think the board's gonna support the objection there probably, just on the basis that
Okay.
her experience may not be reflective of what the DEP does in general. I mean, we don't know
Okay.
exactly what mine she's done or what types, without getting off into all of that. I'm not sure that there's relevance there on what.
Okay, did you have any discussions with Harold Ward regarding the necessity of SHPO's concurrence in this case?
I did not.
Did anybody at your firm?
Not to my knowledge.
What about Tom Wood?
No, sir.
Your firm? Talk to anybody inside DEP
Objection,
about the
she's
necessity.
asked and answered that question.
Well, ask it in a general way, and then she can
And
answer.
I'm asking as general as I can. You or anybody in your firm have a conversation with Mr. Ward or anybody else inside the DEP regarding the necessity of SHPO concurrence in this, the issuance of this permit?
We provided through the permit, it responded to correspondence from our permit reviewers in the Oak Hill office with information as it was obtained. So as we were requested of information, we obtained that information and submitted it back through the permit in the appropriate section.
Okay. Are you familiar with the, I believe it's an October 6, 2013 letter from SHPO? It was actually, the letter was addressed to DEP, but outlined concerns that SHPO had with respect to two topics, archaeological issues and architectural issues.
Yes.
And are you familiar with the letter dated February 20th, 2014, in which, again, it's my characterization, but if SHPO, in essence, desisted its objection with respect to archaeological issues.
Objection, just characterization of evidence speaks for itself.
Can you rephrase that a little bit?
Are you familiar with the February 20th letter?
Yes.
Did you understand that letter to say SHPO's not concerned about archaeological matters in the future?
Yes.
Did you understand that letter to mean that they had retained concerns about the architectural issues?
I understood that they had some additional questions.
Okay, which were sufficient to make them withhold their concurrence, correct?
Objection.
Well, is that your understanding?
Let's let her answer.
I understood they had additional questions.
Were those questions sufficient to cause them to withhold concurrence in the issuance of the permit?
I don't know that they had the jurisdiction to concur or to deny the permit, but I knew they had additional questions of the archaeological firm who prepared the document that had been reviewed to that point.
Well, what's the basis for your confusion about their authority?
The DEP is the one who approves the permit.
And are you familiar with West Virginia Code 22-3-22D2?
Well, no,
It
we
says
can't,
it's
you
gotta
can't
be-
require it to make a
Okay,
legal
well,
opinion.
she's an expert in permits.
She's
and
giving you an answer on
She's
what-
basically saying that, gee, I think,
Objection, you can't characterize what the witness
Sure I
said.
can,
No,
sure
you
I can,
can't.
yeah, I can. For purposes of this discussion, I
ask
can.
her-
Plenty,
We're gonna
plenty. Okay, hang on a second. Let's
We're
get
gonna
20,
ask her to give a legal opinion as to why.
she's already given one, and we're now trying to find out what the basis for it was.
That's untrue.
That she's
Right.
not.
Yeah, well, let's,
She's answered your question, I think, related to what her understanding of SHPO's response was. And I think that's probably a sufficient answer. She can't testify to things that she doesn't know. She gave you her understanding. We're missing a board member right here, so let's take a quick break. So she mentioned,
think he did.
apparently he needed to take one anyway. So.
Pretty good signal.
Well, Mr. Chairman, I want to, believe me, I want to let this, everybody finish today. The board would want, it's 2 days, 2 lengthy days of hearings, on top of 2 lengthy days of hearings and stays, so I want to finish today. And I basically just got 2 questions left for this witness, if I can get them out. And I just got a question on how to proceed here. I've got a copy of 22.3, 22D2 in front of me. It's downloaded, it's a PDF. I don't have it in hard copy. I'll be happy to show the witness my computer, or I'll be happy to let Mr. Hoyer or anybody else that wants to examine this before I present it to her. I just want to make sure I get the question to her.
Can we work with that?
We want to make sure that, we want to make sure that we preserve our objections. And being, she's not a legal expert.
Right.
This is beyond the scope. We didn't ask her to interpret the statute. There's no benefit to this board for her to interpret the statute that you all are going to have to take a look at, and that we have argued pretty thoroughly in our briefs.
Is there relevance to this,
Sure.
considering that she
She's-
can't give a legal opinion?
Well, no, she's been qualified as an expert on permitting of surface mines before this agency. And she's, and I think it's totally germane to that to look to the statute, the enabling statute's permitting authority. And if she's not familiar with it, then maybe we ought to re-examine the whole question of her qualifications. And she's also testified that, I mean, I don't know if she's met hundreds or thousands, but she has participated in a very significant number of permits, and I'm going to ask you a question about that, so maybe if I just get my question out, they can record their objection, the chair can rule, and we'll either have or not have her answer.
Let's see what, go ahead.
I'd like to note for the record, A, my objection, B, my concurrence in their statements. And also remind the board that you're the finder of fact, but you're also the gatekeeper of what evidence comes into this hearing. And Mr. Apollo has gone pretty far afield with a number of his witnesses and our witnesses with regard to the topics and questions that have been asked. This board has the authority to set limits on what is asked of witnesses. And I just think this is beyond the pale. To ask a witness to interpret a statute is
I'm not asking her to interpret, it's cross-examination. It couldn't be more directly germane to her claimed area of expertise, which they offered in permitting. And if she doesn't know the core enabling statutes limits, then I think.
That's a mischaracterization. I've never in my life seen an expert witness testify about, or read a statute into the record, or B, testify about what a statute means, ever. Unless it was a legal malpractice case.
Which is not definitive. His experience is not definitive on that topic.
Well, I think what we'll do, I think we're going to deny the question on this.
Could I get my question on the record for the record? Just verbalize it here so that it'll be clear to any reviewing court what the question was and how it related, if at all, to her expertise or anything else. Okay, my question is this. Ms. Torrey, are you familiar with the West Virginia Code 22.3-22D2, which states in pertinent part that no surface mining operations shall be permitted which will adversely affect places included in the National Register of Historic Sites unless approved jointly by the director and the director of DEP, I believe it implies, and the state agency with jurisdiction over the historic site. Are you familiar? Have you ever seen that statute before?
Okay, we've got that on the record. And do you have another question for her?
Sure. Do you believe you've participated in more or less than 500 permitting processes?
Less than 500.
More or less than 200?
Probably more than, not new SMAs, but various permitting actions.
Okay. Have you ever seen a permit approved by DEP without SHPO approval when an MR-SHPO form has been? Can I get my question out?
Let him ask the
Let me
question.
get the question out. I expect it's going to be overruled, and that's fine, but I'd like to get the question out.
Ask
Right.
the question.
In the somewhere between 200 and 500 permits that you've reviewed, have you ever seen with respect to which the DEP has required the applicant to file an MR-SHPO form. With respect to any of those, have you ever seen DEP proceed without SHPO's concurrence?
Objection.
Yeah, we're gonna sustain objection. I think
Okay.
we've already discussed this and.
That's fine,
gone down
that's
this.
fine. I don't have any further questions for this witness.
Mr. Rist.
Thank you. Okay, first, your original testimony, if you recall back to that, was that the well, the Thomas well was 2,300 feet from the nearest mining, right?
Yes, roughly. Yes, roughly.
Okay. And you're, you are the person that prepared the permit, correct?
Yes, my company assembled permit and did the design work that's included in that with respect to the mining operation.
And you understand that the appellants that have the wells are all bringing up the issue of well water and worried about the protection of their wells?
I understand that.
Okay. And actually, in the permit, it says that the closest well is approximately 1,800 feet.
Yes,
Is that right?
that's correct.
Okay. The second thing is the water testing. Is there anything in the permit as written that tests for issues with hydrogen sulfide?
No, there is not.
Are you familiar with issues with hydrogen sulfide that need to be protected when you create a permit?
Not.
Have you ever read anything written by Dr. Scott Simonton from Marshall University dealing with hydrogen sulfide exposure?
I have not read anything from Dr. Simonton on that topic.
And so to the extent that there should be a protection in a permit for hydrogen sulfide, you, when looking at preparing a permit, would not put that into account when you're trying to do water protection analysis?
Rephrase that, please.
The issue of hydrogen sulfide, that's not something you take into account in protecting water, correct?
That is not one of the listed parameters either in our Article 3 or our NPDES.
What types of metals are released from mining activities? Do you have any idea?
Typically, historically, if there are unweathered minerals that come out, it's the ones that are standard monitoring parameters under Article 3 and NPDES, the ones that we look at on baseline, such as iron, manganese, and in some cases aluminum. Those are present in the overburdens.
Okay, and when you say they come out, what does that mean? How do these come out, so to speak?
Well, as unweathered rock is exposed to water and water flows over it, there is a weathering process that some of those metals will be suspended in with the solids that travel over through that water. In this permit, we have a material handling plan that captures those minerals that were determined to be potentially acid toxic, which might contribute to a leachate, and those are encapsulated in isolation zones. Section 08 of the permit.
The isolation zones, are those when these minerals are exposed, as you said, or maybe I'm using my own words now, but is that sometimes by rain events? Is that correct?
Yes.
So are any of these areas where you guys are trying to prevent these metals that could be exposed in mining, those are supposed to be caught somewhere on the permit and kept in that area, is that right?
They'll be captured in pit and on the drainage ditches and sediment structures that are designed and are being constructed along the permit perimeter.
Have you seen, in your maintenance of permits, have you seen structures such as those fail during a significant rain event where water came out over them and went downstream?
I have seen them discharge, but very rarely on the on-bench, because most of those are confined to very small drainage areas, and they're typically oversized.
Did you guys, I'm saying you guys, I guess, to refer to your company, did you guys do any groundwater modeling on this mine site?
We did not.
Dealing with the issue of blasting that you testified about, would you agree with me that notice that blasting could occur between sunrise and sunset is general?
I think it covers the times that it could possibly occur.
I mean, that's just basically business hours, is that right?
No, sir, I think most of the mining operations work at least 2 shifts a day and sometimes 3.
In the permit itself, part of the blasting plan that was prepared by you, and this is certified record 2250, and I'm happy to show this to you or get one out too if you need to refer to it. I don't want you to feel like you can't look at what I'm looking at. But it notes that, and you were in the room when we were dealing with the testimony last Monday, right?
Yes.
Okay. And so you saw that blasting notice that came to Ms. Boulis,
Yes.
right? And that blasting notice was just here, this for a whole year, right?
Yes.
Would you agree that that's a pretty general blasting notice?
I think it's the intention of the I can't state to the intention. I think that we present that to the residents nearby through certified mail so that they will be aware that this is still an active operation, and those are the times that it could potentially occur.
Any time in a whole year?
Anytime in a whole year with the restrictions specified in that document, which I believe were sunrise to sunset, no blasting on Sundays, and I think in this particular permit, if I recall, the conditions that were assigned on the face sheet actually restricted it from Monday through Friday.
And you're in the permit itself where it has blasting schedule shall not be so general as to cover all working hours, but shall identify as accurately as possible the location of the blasting sites and the time periods when blasting will occur. Your testimony is sunrise to sunset, Monday through Friday, is specific enough to give residents in the area notice as to when this is happening.
It's the standard presentation, not just in this permit, but in all permits. I'm sorry. That's the standard schedule that we use following the OEB recommended documents, and it's in not just this permit, but all permits, or most permits that I don't know of any others and have not done others that are more specific than that.
Okay. Let me talk to you about this park issue. You're the person that filled the permit out, so I'm gonna guess that on exhibit number 10 that's up there with you, that had the checkbox, will any publicly owned park be affected by the proposed operation? You're the one that checked no. Is that right? Or someone from your firm?
Yes.
All right. It was earlier represented that was just a typographical error, is that correct?
Objection, was not, we made no such representation, was informed.
Can you rephrase it?
It was a
maybe?
question.
Is that a typographical error?
No.
Okay, that you intentionally put no, because, why?
Because there is no mining that will encroach onto the permit boundary. The original design maintained the proscribed 300-foot boundary as the regulations call for from a park, and the company further restricted their activity to avoid and minimize any impact. So in my contention, there is no adverse impact to the Kanawha State Forest.
So you're saying, and this question isn't, is there mining gonna happen in Kanawha State Forest? It's, is there any effect on the forest, right?
Objection asked and answered.
And you heard the DNR chief say there is an effect on this forest. He testified to that the users of the forest are going to be affected by this permit, right?
I heard him say that, yes.
Okay. And Exhibit 6 is a letter to you back in July of 2010. Do you have that up there?
Which one?
6, please. gonna give you a second to look at that as well, okay? Have you had a chance to look at that?
I have looked through it, yes.
Okay, and this is a letter directed to you is it Dakota?
Yes,
Dakota?
it's actually misspelled there, but that's close enough.
Wh-
There's
which-
no capital in the middle.
All
It's-
right, but is that your correct address?
Yes,
Do you recall receiving this letter?
yes, I hadn't looked at it for a long time, but yes.
But you don't, let me ask you, at the time that you received this letter, this is from the DEP, this is from Tom Clark, is that right?
Yes,
It's copied to Frank Jezero,
yes,
who's at the West Virginia DNR, right? And did you know at the time that that's where Frank Jezero was employed?
yes,
All right. This letter says from the DEP that Canal State Forest is a park, right? You don't
That's what-
disagree with that?
that's what the letter says, yes.
And so the DEP sends you a letter and identifies this area as a park, and also identifies in the letter that the DEP has determined it presents the potential to adversely affect Canal State Forest, correct?
That's what it says, yes.
And that's 2010, yet when the permit application is filled out and you're asked, is any park gonna be affected, you check no, right?
Objection, asked and answered.
Yes.
I mean, that's part of the record, but now what I'm asking you is, you were told by the DEP that it was a park, correct?
That's
Again,
what-
objection, asked and answered.
Yeah, can you phrase the questions differently?
Where is attachment G1?
Beg your pardon?
Where is attachment G1?
G1
Yes, ma'am.
in section G of the permit application?
There is an attachment G1 somewhere that the public was able to examine prior to the permit being issued?
No,
And isn't it true that when you
But-
check no, that there's no publicly owned park to be affected by the proposed operation, you don't attach an exhibit G1, correct?
that is correct.
Those are the only questions I have. Thank you.
Mr. Lund?
I don't have any questions, but thank you for your time.
Mr. Jones?
I have no questions.
I have two quick last questions, I hope. Approximate original contour. Could you explain to the board if this is that type of permit and what that means?
Objection. They objected to my asking her legal questions. That's a clear legal question. She has no demonstrated competence in that area. It's way beyond permitting, which is the only area she's been qualified as an expert in.
It's in the permit.
The board understands that determination has to be made in the process of making a permit. And so we'd like to hear the answer to the question.
Thank you.
Approximate original contour is an evaluation of the regrade plan associated with the permit that demonstrates compliance with the DEP policy relating to recontouring the permit as near as possible back to the original contour of those areas that might be excavated.
One last question. This is a no discharge permit, is that correct?
That is correct.
And could you explain to the board what that means?
Same objection.
So overruled. Go ahead, sir.
Thank you.
The drainage systems, including the sediment control ditches that capture all of the surface runoff over active and reclaimed portions of the mine, are designed so that they will capture and not convey any runoff. They can convey up to, in an extreme rainfall event, up to a 25-year rainfall event, they may discharge. But on a normal basis, due to the size of the ditches and the limited drainage areas, there's not expected to be a discharge from this permit on a regular basis.
That's all the questions I have. Thank you.
I've got a follow-up on that.
Sure.
Was that a rainfall event that happened in 2003 when Loudondale flooded, a 25-year event?
I don't know if it was a 25-year event.
Or was it a 100-year event? You have any idea?
I do not know.
Do you know whether this mine and these catch basins that you're talking about, and I know I'm using the wrong terminology, that those would hold the water that fell during that rain event?
I know that they would have been inspected during and post the rainfall event. It's part of the operational practices. So they may have discharged water in that event.
No, I mean the mine permit that we're looking at. You're saying that it's a no discharge mine.
Oh.
But it's only designed for a 25-year event, correct?
That's correct.
And so whether or not it would have held back the event that just happened a decade ago,
It would discharge, the design structures are designed to discharge and safely convey a 25-year rainfall event. They are also designed with an extra foot of freeboard, and that will give an additional capacity to safely convey any runoff from that type of an extreme rainfall event.
I don't have any other questions. Thanks.
Nothing further.
Nothing.
Anyone else? The board have questions? Right ahead.
A couple of questions.
Okay.
On the blasting, how long of a period, a year, 2 years, how long is this mine going to be in existence where it'll be blasting?
It'll be about 10 years,
10 years?
roughly.
Okay. And how often during a month do they blast?
Depends on the depth of the strata that they're working in. If it's a thin interval between one seam and the next, they may blast a couple of times a week. Bigger blasts, it takes longer than that to prepare them, and some of it will depend on the sequencing of their operational equipment, whether they're having to bypass that active shot preparation area as they're hauling coal out or whatever. So they may do small shots in certain areas that are closer together, so that maybe once a day, a couple of times a week.
So we're possibly looking at somewhere around 100 blasts a year, just,
I think that's possible.
yeah. Do you think any of the blasts would be heard by bikers or people who are walking in the Kanawha State Forest?
They might be.
They might be? Okay. Back to the mine modifications. I think you said that mine modification does not require, to inform certain people other than put it in the newspaper. Was that correct? Explain that to me.
Some of the permit actions, if they're deemed insignificant, if it's then they do not require a public notice. And the permittee will prepare that application and submit it directly to the regional DEP office that's reviewing it. And then the correspondence is directly to the DEP. And I guess upon approval, it becomes a part of the permanent record.
Okay. Now, in this case, since the DNR was involved in, in commenting and approving, the permit, and SHPO was also involved, would they be informed and have, if there was a modification to the permit?
Typically, SHPO is involved in the types of permit actions such as a new permit or a boundary revision that would add more than 5 acres of property adjacent to the existing permit. So they would be notified in those situations.
Okay, and what about the DNR? Same thing?
The DNR, this is the first permit that I've been involved with that the DNR actually commented or was involved in.
Okay. But unless it was a major modification, the citizens around there wouldn't be notified, or may not be?
They may not be.
Okay.
It would not be published unless it was a significant
Okay.
permit
Thank you.
action.
I have one question, if I could.
Yes, sir.
And this may not be, it may not be what I need to be asking you, but the thought just occurred to me. I've heard about blasting and trails being closed, I presume because of blasting, maybe some effect blasting might have, or, and signs posted. And I'm just wondering, does the permit, and if this doesn't, if something's not involved in permit, it's involved on enforcement level or something, you just tell me, but does the permit have a mechanism or a description for exactly what the process is when you get ready to blast? I mean, do they have to check the trail, or is there's sirens that go off or something? I mean, how does the permit address the issue of someone that's over in the park when they get ready to blast?
The permit has a stipulation in Section T that describes the safety measures that will be taken. They include warning sirens. I think in this case it's an air horn. It includes sending representatives of the mining company out to access roads and blocking those. So those safety precautions with respect to guarding a particular blast site from any unexpected access from someone who might not be authorized to be there, those are spelled out in Section T of the permit.
Okay.
I got a follow-up on that. Okay, if I wanted to go out and hike through the Kanawha State Forest, how would I know prior to going out there that there's going to be blasting? I mean, we're talking about, do we have an impact on the people who use the forest? And if they come out there and then all of a sudden they're said, no, we're sorry, you can't go today because we're going to be blasting, that might cut back on the number of people who want to go out to the forest.
It's been my experience that when they set off a blast, the whole warning and the time that it takes to let the blast off and to clear it takes 5 to 10 minutes. So they're pretty careful and pretty controlled in how they stage those up. And as soon as the particular blasting area is prepared, they'll try to go ahead and put the shot off. And as I said before, they try to do that at shift change to minimize the impact to their own employees traveling to and from the particular work sites. So, but typically it's not going to be an extended period of time. It'll be just a few minutes.
Well, I understand the safety and mainly for, for employees and such, but I'm still worried about, it seems to me there ought to be a better way to inform the public before they go out there that something's likely to happen that day. I don't know if you can have a homepage, that people could check into and say, or, I mean, I'm not sure what it could be, but it seems to me there ought to be a better way to let people know that this is going to happen, and besides just the residents and the employees. Have you considered recommending anything like that?
I have not. I mean, that's not something that we would put in the permit. It's not something that the company had asked me to investigate.
Thank you.
If I could, just to follow up on that, if I could, Ms. Torrey, 1 second. Again, the blasting evolution itself comprises at the most 15 minutes.
Most likely.
Most blasting evolutions once a day,
Yeah.
or twice a day at the most would encompass 15 minutes. And the portions of the park that affects are the bitter ends of the Polecat Trail, the other trail, and the road by the shooting range, right? It's just the bitter ends of those trails, right?
Yes.
It's not the entire trail. It's a very limited bitter end of those trails. Is that correct?
That's correct.
No further question.
And I'm sorry, we're redirecting on redirect of redirect.
It goes on until we get done, I think.
Thank you. I appreciate that. When he's talking about the bitter end of like Polecat Trail, I mean, to a mountain biker that's coming up Mossy Rock Trail, are you familiar with the trails in the park?
I've been to the trailheads of Polecat, Lindy, and I think there's a third one on that side.
Ballard.
Ballard.
They're all down on on the
the
bottom
road.
road going to the shooting range, right?
That's correct.
And you guys are proposing only to close that road and the bottom of those trails, right?
I believe that was the stipulation in the permit.
And so as far as stopping mountain bikers who are very commonly go down Polecat and Ballard Trail, from going down those trails and ending up at the bottom behind the people that are supposed to be stopping people from the trail, you don't have anything in the permit to stop that, do you?
I believe there was at least a discussion, and this may be something that's not permitted, but through inspection and enforcement, that they would have someone check the trails. I mean, several hundred feet up the lower end of the trails, just for safety.
If it's a 10 to 15 minute time that it takes to set this off, when is it they do that versus when the blast is set? I mean, if someone's not standing there saying, no, you need to wait before you go down this trail, you can drop Polecat Trail probably in about 2 minutes or less on a mountain bike.
Yeah. That'll be something that when the company approaches that part of the operation, when they're close to it, I think they will have that sorted out with DEP by then through inspection and enforcement.
I think I'm done this time. I know that's the third time I have told you that.
Okay. Any other?
I have no further questions, thank you.
No further questions.
Any other questions from the board?
Thank you, Linda.
We're done, thanks.
Thanks.
I have no further witnesses.
All right.
We have no witnesses.
If I might, I don't kind of,
Excuse me. So you guys
We rest.
rested?
We have
We
rested.
Okay, thank you.
I don't contemplate calling any rebuttal witnesses, but there are a few ministerial items here to take care of.
Okay.
First is items 0, 1, 2, and 3. 0 is simply a filing of the CVs for Mr. Wood, CVs 1, 2, and 3, which I believe the board requested at the last session. And I guess as a technical matter, I'd like to move their admission. If somebody wants Mr. Wood to get on the stand and raise his right hand and say those in fact are his resumes, I'll be happy to have him do that. But in any event, I want to move their admission. And lastly, only because I'm sure the court will grant it and there will be no objection, I move the admission of Exhibit 9, the August 18th, 2004 SHPO FOI response, including the memorandum of agreement.
Well, I object to that.
I'm sure-
Relevance here.
Let's see what that is.
Also, there's been no foundation laid for it, so, I mean, there's a relevance objection, there's an authenticity objection.
Which
It's the one.
Well, I anticipated all that, and I'm nonetheless making my motion, and the board can rule.
We can leave it.
But I guess, is there any objection to items 1 to 3?
No.
Okay. Let's,
And I'd also like to just
go ahead.
point out that items 4 through 7 are matters of law that the agency can and needs to take administrative notice of.
Okay. Items, the first 3 or 4 items, 0 through 3, did the board request those? I don't think we did.
Well, actually, and maybe I'm misspeaking, but I believe it was Henry Rauch who was here the last time. I think the DEP council requested it. He said, well, would you have your lawyer, or would you give your lawyer a copy of your resume and have it forwarded to me? And in fact, my client sent it to the council directly. But I would not have bothered that candidly except for the fact that Mr. Rauch, I believe, was the one who requested it, and so I proffered it solely because of the request from the board. Candidly, I don't feel any compulsion to have it admitted or not. I just want the board to be aware that we complied with the request.
How do you feel about that, Mr. Long?
I have no objection, and I would like to just follow on and move the admission of Ms. Torrey's resume that was presented as permittees Exhibit 1.
Okay, well, let's admit this 1, 2, and 3 out of this that Mr. DiPaolo requested. And number 9, I think we'll leave that as part of the record because there seems to be some problem with the completeness of it and the foundation of it. So let's leave it in the record. But we only have part of the document, so we can go ahead and leave it in there for, we'll give it weight as we deliberate. But I don't think it being complete or having a complete foundation that we can put it in. So I don't think we'll officially admit that one. And yours was?
Permittees Exhibit 1, the resume of Linda Torrey.
Any objection to that being
Is
amended?
that just the one-page document? Because we were given a lot of different documents.
2 pages. It's 2.
Oh, it is 2 pages,
Yeah,
okay.
it's 2 pages.
So
So that would be Linda Torrey's resume,
Yes.
2 pages long.
Yes,
So
sir.
we'll admit that.
you gave me 2 copies of that.
Oops.
But no objection to it, it's fine. Thank you.
We'll get you one, Tom.
That's okay.
Okay, do we have any other issues as far as any?
I have none.
Can we go off the record then?
Yeah.
So we got to decide what we're going to do. Okay, so we're on the record. I think we've all agreed that all the parties will submit their conclusions, finding of fact, within 15 days from the time that they receive the written transcript, and that then the response would be 10 days after they receive each other's facts.
The 15 days is business days with 10
Calendar.
days.
Calendar days.
But the 10 days is calendar days.
We'd like to have it all calendar days, if we can agree to that.
And if it lands on a Sunday or a holiday, it kicks over to the next business
Yeah,
day?
sure.
And should we, and I think maybe the talking or sending an email and saying, here's the 2 dates we agreed to or whatever, but we might want to agree, okay, on this date, you're going to email and mail if you're going to mail it. That way someone's not, well, I mailed it that day, sorry, and if you guys want to agree to that.
Electronic submission is nice.
I'm sorry?
Yeah.
Electronic submission is,
And if you have
in
any,
addition to paper submission. is
Yes.
good.
if there's a problem and you can't agree, the board probably get involved, but. Okay, are we done?
All right,
We're off
are we
record.
done? All right, thank you very much for your
Thank you,
Oh,
guys.
really? I talked on the record.